Thank you very much. It's a great honor to be here and to share the platform with Professor Lapidoth and Dr. Gauthier. I naturally prepared a long paper, which I will not read to you, but will submit for the record. I thought I'd begin by posing a question. What if there hadn't been a Balfour Declaration? Would Israel exist? One could imagine the British deciding that Palestine really wasn't an important piece of real estate in terms of Suez or anything else, and not wanting it as part of an additional imperial possession. One could imagine Syria or Jordan, what is now Syria and Jordan, dividing it, or just being part of Syria, because it is said that the Arab inhabitants of Palestine at the end of World War I thought of themselves as Syrians. But whatever, I think one has to come to the conclusion that but for the Balfour Declaration, Israel would lack the kind of strong legal basis it has. And that basis is more often ignored than respected, and so I want to spend some time talking about it. The other point is that even if Israel had come into existence, it would have come into existence in a different way, in a different context. And it's that context which the Balfour Declaration gives. And there are three parts to the Balfour Declaration, of course, and each one is relevant today, which is perhaps not something to celebrate, because the third part is that the status of Jews in their country of origin will not be affected by the Balfour Declaration. And as we all know, there's an awful lot of anti-Semitism that's awakened in places where it hadn't been seen in this form in a long time, to wit my own country. And so perhaps that should give us some caution as we celebrate a very important letter, as we were told. So Professor Lapidoth has given away the secret of the whole thing, which is that the League of Nations mandate for Palestine took the language of the Balfour Declaration and made it an internationally legally binding document. And for the first time, Jewish rights in Palestine, in the territory of the League of Nations mandate, became part of modern international law. I would also argue that it represented a facet of the law of self-determination, which the League of Nations made the governing principle of all colonies, whether or not in the mandate system, and that Arab rights and Jewish rights stem from the same source. But let me get to that a little later. The British, of course, after World War II, faced the problem of overextension and destruction. After all, two world wars destroyed European dominance. And so they looked to the General Assembly for a recommendation as to what to do with their mandate as they prepared to withdraw from Palestine. And the UN General Assembly in 1947 recommended partition of the Palestine mandate, as it was, from the Jordan River to the Mediterranean among a Jewish, Arab, and international zone. And that recommendation was never made legally binding, because it was a recommendation to Britain as the mandatory power, and it was a recommendation to the UN Security Council. And the Arabs opposed it, and the Jews accepted it, and war resulted before anybody could make it legally binding. And so, as we all know, Israel emerged from the war of 1948 with more territory than the 1947 partition resolution contemplated, which is one of the reasons why opponents of Israel invoke the 47 resolution as if it were a piece of international law, but it is not. Now, how did the mandate become part of modern post-World War II, post-UN Charter international law? It became part of the law by virtue of Article 80 of the UN Charter, which was known as the Palestine Article, and which provides that pre-existing rights under the mandate system continued until replaced by new agreements. And the first new agreements under the UN system were, of course, the Armistice Agreements of 1949. And they were treaties between Israel and Lebanon, Israel and Syria, Israel and Jordan, Israel and Egypt. And they included the demarcation of armistice lines, which by their terms were not to be final borders and final conclusive settlements of all claims. Now, Arabs who had left Palestine, well, had left what is now Israel for whatever reason, might have claims, but Israel might have claims to the part of the Palestine mandate it had not been allowed to settle in, too. And then, of course, there are claims that Jews expelled or forced out of parts of the Arab world might have. So one could imagine if the U.S.-Iran Claims Tribunal is still going nearly 40 years after the establishment, that one could imagine a really lucrative career for lawyers settling Arab-Israeli claims forever into the future. Not a, you know, it's tough times for the legal profession. Don't look askance at the opportunity. Point being that these first post-mandate agreements were didn't settle boundaries, but the Security Council, very interestingly, used the magic word decides, making them binding on all the parties. They saw, the council clearly saw them as a first step toward peace. Did not see them as final boundaries, but saw the agreements as inviolable and a first step toward peace. Well, if you take the Israeli-Egyptian peace treaty, it took 4 wars and almost 20 years before, 30 years before that Armistice Agreement was translated into a peace treaty. And so, and a further, 15 years before a similar treaty with Jordan replaced the Armistice Agreements. There's still no peace treaties with Lebanon or Syria. And that's an important point to keep in mind, that we still have a long way to go on part of the Arab-Israeli conflict not having to do with Palestinians. Now, in the intervening period, the question has arisen several times as to what is the state of the law, what is Israel entitled to do across these armistice lines. And I was reminded that the old Green Line goes right through the Mamilla Mall. An interesting thought as you march through it and say, well, of course, it's going to be reestablished, as some people think it should be, as the boundary. I wouldn't bet on that. The question that always arises in international legal settings is who decides? And we had a decision, an opinion of the International Court of Justice, of course, in 2004, saying that Israeli construction west of the armistice lines, no, east of the armistice lines, sorry, was unlawful, but they didn't say where the boundary of Israel is. And so the Arab judge on the International Court of Justice could scarcely conceal his glee in his concurring opinion that the majority of the court never said where the boundaries were. So now in 1994, in an ICJ opinion on nuclear weapons, the court said its opinions have to be appreciated. That is, whatever that means, it means understood in the context of the subject matter and the question asked. And the court in 2004, as was revealed by the Moroccan ambassador to the UN at a conference at Columbia's Law School, said, oh, it was just a political act to try to increase Palestinian leverage. And so it's what we would call an act of lawfare. And how to appreciate it, I think we need to understand it in that context and to not take it as authoritative on the question. Similarly, the resolution last December, which condemned Israeli settlements and building activity outside the Green Line as totally unlawful, needs to be understood in context. There's a very interesting piece by the British Jewish Chronicle that reveals that it really was just the Obama administration going out of office in a fit of pique, which the rest of the world allowed it to do. And, but, you know, UN documents, as Ambassador Gold knows, are funny things. And this one contains its own internal contradictions because it reaffirms Resolution 242 of 1967 and 338, as well as resolutions condemning all Israeli construction. And of course, Resolution 242 remains the one UN framework document for peace in the Middle East which all parties refer to, and they say they are abiding by, and which all Israeli-Arab agreements since 1967 have complied with, whether they were with Egypt or with Jordan or with the Palestinians in the Oslo process. So it's important to remember not only the context of Resolution 242, but what it actually provides, just as it's important to think about the Balfour Declaration in all of its parts. And 242 famously treated Israel as the victim of aggression. And early drafts called for an Israeli withdrawal from all the territory occupied in the war, and the draft adopted unanimously did not do that. The Americans in particular said we had forced Israel out of Sinai in 1957 without getting a peace agreement with Egypt, and we weren't going to do that again. And so the withdrawal provision contemplates an Israeli withdrawal from occupied territories to secure and recognized boundaries, and the boundaries were to be adjusted in Israel's favor because Israel was the victim of aggression. Second thing about the 242, which is relevant to present day realities, is the call for an end to states of belligerency. And so that applies not only to all states in the region, but also to the Palestinians or any other would-be state. If a group wants to be a state and a member of the United Nations, it has to demonstrate, at least in terms of the UN Charter, that it is a peace-loving state. And in my view, acceptance of Israel is not a bargaining chip, it is a requirement. And it's not something the Israelis should pay for. Now, the third thing about Resolution 242 is that it calls for a just settlement of the refugee problem, and now the refugee problem is the Palestinian problem. And whether one likes it or not, agrees that it should be or not, the Palestinians have been accepted by the international community and by Israel itself as a national entity, indeed perhaps even a state. So an agreement is required, but it's a two-way street, and you can't have real peace in the as long as Israelis believe that the Palestinians have not given up the dream of replacing Israel with something else, and as long as the Palestinians believe that the Israelis are not serious about wanting peace, or that they have no historical connection to the Temple Mount, or that it shouldn't be called the Temple Mount. I was reminded the other day that at the UN they never use the term Temple Mount, and so forth. Now, I said a moment ago that it depends who the decision maker is on international legal matters, and that's truer with regard to the Israeli-Arab conflict than any other area of the law, I think, of international law. Correct me if I'm wrong. But I think we're not going to see, at least in the new from the Trump administration, acceptance of another resolution as was adopted last December. Whether or not the administration can achieve more than that remains to be seen. But let me just close by saying that the sum total of my remarks is designed to show that the Israelis have solid legal claims to exist under international law, to be accepted under international law, and they have territorial claims of right, not just security, which have to be addressed. Now, if you have a territorial claim of right, or any claim, whether it's you claim a right of return, which does not exist in international law except in certain treaties, but you don't have to exercise it. You can renounce it in exchange for something more valuable. Thank you very much.